Good morning, Eric.
Good morning, Jen. How are you?
I am well. How are you?
I'm doing pretty good.
Pretty good.
Yeah, well, thanks for being here today. Thanks for everybody who's listening, watching, whatever this is, podcast, video, we don't know yet.
Maybe.
This is Just the Tips with Jen and Eric, and today we're going to be talking about arbitration as an alternative dispute resolution method. Um, we review a lot of contracts. One of the areas that we focus on, that we spend time looking at, is the dispute resolution provision in the contract. And, one of the reasons is because we want to look at what you're going to be obligated to once, in the event that there is a claim or an issue, and how that procedure is going to go down. And in terms of contracts, it can be anything from project managers getting together and talking all the way through to full-blown litigation. However it gets set up in that contract, that's what we look at. So today we're going to focus on the arbitration piece of it, right?
Yeah. So clients usually don't like to talk about that part of a project, right? The part where there might be a dispute, but it's part of what we do. So we have to look at the big picture and the what ifs and make sure that we're
It's like
dotting
a
the i's.
prenup for a project,
For
right?
sure, for
Yeah,
sure.
you
Nobody
gotta
wants to
talk
think
about
about
what
the
happens
divorce,
if it
but
goes bad.
there's a there's a high probability. So so anyway, that's yes. So we have to look at it. So arbitration is a procedure where disputes are handed essentially to an arbitrator or a panel chosen by the parties in the dispute to make a binding decision on that resolution. So let's break down some of the other ways that you can resolve a dispute. So the very informal, the project manager is getting together in a room, making a decision. If that doesn't work, you might have some higher level folks coming in, principals, et cetera, from both sides
And I
coming
like
in.
that. I like that setup, because
Sure.
we always talk about, the tone of a contract and, sort of getting a sense for all of that based on the language in the contract. And I think when the other side is already setting the stage for, we're going to work through these things amicably, that's a positive sign
Yeah,
when it comes to
it's
looking
a
at
very
contract.
mature sign
Hmm.
of either someone who is used to drafting contracts or parties to the contract that are used to being in projects and
Yeah.
how they're handling
And
it.
we,
So
we
yeah.
always see, and I'm not going to get off topic here too much, but we see provisions in contracts that sometimes we look at and we say, wow, that's really good, or oh my God, that's horrible. Where did
Hmm.
this language even come from? And it's usually born out of that that company that drafted the contract having been burned on something,
Right, right.
something
Yeah.
specific that created this need for the language. So usually when I see
Like warranty
that,
statements, disclaimers on products,
right,
right? Don't use this
yeah.
to trim your hedges.
Right.
Right.
But when I see those very, very informal steps to alternative dispute resolution, it means, somebody's been dragged through the mud before and thought, you know what, this process isn't worth it. Let's contractually mandate, an easier way for us to discuss these things and work through it. So,
Sure,
so that's a
sure.
good thing. Anyway, sidebar over. Continue.
No, no, of course, of course. So we've got the informal. There might maybe a little bit of an escalation on who's involved in that informal. Love to see that. What I'd love to see next is mediation, which is just a formalized version of that. Let's get together and talk it out. But we're going to choose a party to make that decision for us. The beauty of mediation is that it's not binding, right? So if either party or all the parties decide that they don't like the way that this was decided, they can walk away from it
There's
and
some
then move
recourse.
along,
Yeah.
yeah, to the next step, the next escalation of aggression, if you will,
Right.
in the dispute. So, you've got that mediation where in a good mediation, everybody walks away unhappy, right? That's the
That's the old saying.
if it's a good negotiation, no one's happy. So then you have the choice, and AIA has this in their documents. You can choose the next step to either go through arbitration or litigation. Now, remember, arbitration is that procedure where someone is chosen to make a binding decision.
So that's interesting. the older AIA documents used to allow you to opt for mediation also,
Correct.
right?
And now
And
they're
now
inclusive.
now that's just a standard operating procedure within the AIA forms to, you start with mediation and then you can choose from there. But
Right, right,
hasn't always been the
absolutely.
case.
So you've got arbitration, that arbitrator or panel of arbitrators that make a decision, and then you've got litigation, which is your public court policies, right? So you go through that system, and that either goes through being decided by a judge, being decided by a jury, or a settlement, depending on what's happening in the case. But we always recommend that our clients choose litigation over arbitration.
Right, and the response is always kind of the same thing. Well, litigation is just such a, it's a time suck and it's a money suck and all these other, uh, you know, arguments against it. So what's the deal with arbitration? Why would we choose to litigate
Over
instead
arbitration.
of going through an arbitration?
Yeah, so proponents of arbitration say things like it's less time consuming, it's less costly than a full blown litigation. It should move things along and keep some of the bottlenecking out of the court system, out of the public court system, and and move things along in a way that makes sense for everybody. The problem with arbitration and arbitrators is that they're not all familiar with the responsibility of a design professional. And it's been our experience. Anytime I've seen arbitration, it hasn't been particularly, uh, helpful. It hasn't been less costly, hasn't been less time consuming than a full blown litigation. So I haven't seen it from that side. The bigger problem, however, is there's usually multiple parties that are involved in a dispute. And so let's say, for instance, you've got your client who's the owner, project owner. You've got a contractor. Maybe there's a project manager and you, the design professional, you're all involved in this dispute. And you have to come to a decision on choosing an arbitrator to make that binding decision. Okay. So the choice is made, and it's three folks who are choosing, who have um, closely related liability responsibility. And you, as the design professional, has this very different responsibility liability standard of care. And so, where you may have you may be up against a bit of a hurdle there if you've got other people choosing an arbitrator who may not have the experience of understanding the difference between you and a contractor and your responsibility.
Right.
The other issue with arbitration is there's only one shot. You have a single shot at getting it right. There are no real discovery rules outside of what is established. Your attorney has one shot to kind of lay out everything. Um, and what we see often in decisions in arbitration are, sometimes it's a little bit of splitting the baby. Sometimes it's a decision based upon contractual rather than tort liability, no real delineation between what's what, um, and really hard to project what an arbitrator is going to decide. So there's no appeals process. This is binding. So outside of collusion, fraud, those kind of things, there's no way to say, hey, I don't like that decision. I want another one. I'm going to appeal this decision. There's no
Right, or
process for that.
procedurally, I think something, may have been off, or there was this piece of information that we didn't get to bring to the table, or that we didn't bring to the table, and so, there's no coming back from that once the decision is made.
Yeah, there's no coming back from that. There is only the information that is placed in front of the
Right.
arbitrator to make those decisions on, right? So they don't have access to all decisions, et cetera. And not that it's impossible, but the experience that we've had in the way that arbitration has gone sideways for design professionals, because it's usually they are the minority in the responsibility
Hmm.
and their tort liability versus contractual liability. And that, like I said, splitting of the baby. I saw one many, many years ago where it was the attorney involved and the claims adjuster and us and the design professional who thought that the design professional's culpability in a claim in a dispute was very, 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 very low. They had it valued very low. They expected, a certain outcome. They expected max, maybe 10% of the liability total value. And what ended up happening was they ended up paying their full policy limits and they ended up being responsible for 90% of the claim. And there's no coming back from that. There's no appeals process. That's it. It's binding.
Yeah.
So that was the worst that we've seen, but we have seen other ones that have, similarly gone sideways.
Yeah, and like you said, we've the arguments in favor of arbitration are that they're faster and less costly in terms of attorney's fees and other expenses and things like that. And we just really haven't seen that to be true. I think arbitration does have its place.
Sure.
I think in the construction world, it's more common, and that's really where we see it come into play more often. For design professionals, for all the reasons that you just discussed, it really is something that you should take out of the contract because it can go sideways really easily. But the thing that I think design firms need to keep in mind is that if you're being hired by a contracting entity, you're being hired by the GC, for example, the contract that they signed with the owner likely has an arbitration provision in it that will probably pass down to you as the design firm as well, right?
Mm-hmm.
So we need to be aware of that and be conscious of, when we sign these subconsultant agreements, that incorporate a prime, and it's a discussion for another day, another episode of Just the Tips. But those provisions that pass down to you through incorporation of that prime agreement, a lot of times those are not favorable contract provisions, so we have to be aware of those things too.
Sure. Flow down is really an issue, but how do you handle when someone is insistent upon having arbitration? Do you have any side notes there? Do you make any recommendations?
Yeah, I mean, so it's funny, the people who really seem to be huge proponents of arbitration are people who either are in the construction industry, they seem to really love arbitration, or people who have never been through an arbitration proceeding. Those are anybody in the design realm who has tend not to be in favor of it. But we do get those instances where the client pushes back and says, no, this is standard, this is what we do. So we try to mitigate that. We try to make it so that those other alternative dispute resolution methods are a condition precedent to arbitration. So if you absolutely have to do it, try to go through, internal negotiation process like we talked about before. Try and go through a non-binding mediation process, in good faith to resolve the issue prior to getting to that arbitration. And then if you can, limit the arbitration to a certain dollar amount. So disputes under X number of dollars, we can arbitrate. But anything above that, anything past that, we're gonna go through a full litigation process to make sure we get this thing right.
Yeah, absolutely. Makes sense. So if you are able to negotiate arbitration out of your contracts in favor of litigation, we say do that every time because
Every time.
Arbitration can be arbitrary. I know, isn't that? Oh,
boo.
boo.
Yeah, and listen, it's not just because we're trying to get the lawyers rich. It doesn't have anything to do with this. That's not why we want you to litigate. We just think it's a more fair way of doing it. And it's not just us. The insurance companies would also prefer that you don't go through the arbitration process and instead go through a mediation process. So much so that for most insurance companies, they'll give you a deductible credit. So they'll refund something like half of your deductible up to a certain dollar amount if you successfully resolve a dispute through mediation. So and for some firms, it could be pretty sizable.
Yeah. Oh, for sure. I've seen too lately that the mediation provisions include timeliness of settlement, right? So they want them settled within a year or, X number of months. I've seen some of those conditions put on there, and anything to is speed it up a little bit, get things moving, get things resolved, get it off your loss runs
Yep.
faster, closed out, get rid of it. But there are absolutely a lot of advantages to going through both informal and then formal mediation prior to getting to the big guns. And like I said before, no one wants to talk about the dispute that may happen, but we have to live in a world of what if.
Right.
Worst case scenario, we want to walk you through those things so that you know what you're walking into. I love that a prenup for a project because it's like a marriage, and a lot of marriages don't end well.
Right. Yeah. Yeah. Talk about how to work through that on the front end. That's
Yeah.
always smart. All right. Well, that's the quick and dirty on arbitration. If you have any questions, anybody wants to talk more about that, you can always reach out to us. We're always available to talk. Um, Thanks for joining us today on Just the Tips with Jen and Eric, and we'll be back next time with another amazing topic to talk about.
Another amazing topic. Thanks so much,
Thanks a
guys. Bye
lot.
bye.